Good morning, everyone, and welcome. We have over 200 registered for today's webinar. My name is Janice Sarah, and I'm a professor of law at the University of British Columbia. I want to start by acknowledging that UBC Vancouver is located on the traditional, ancestral, and unceded territory of the Musqueam people. The Canada Climate Law Initiative is a collaboration between UBC's Law School and Centre for Business Law and Osgoode Hall Law School in Toronto. Our goal is to advance knowledge on the scope of fiduciary obligation in respect of climate change and effective climate governance. We have a very active program of climate governance experts in which 55 highly distinguished speakers from capital markets, law, accounting, etc., are donating their time to speak to Canadian boards of directors and pension boards on effective climate governance. So please check us out. Today's webinar is particularly important. Our keynote speaker, Carol Hansell, is one of the most distinguished corporate lawyers in Canada, founder and principal of Hansell LLP. Her recently released legal opinion on the responsibilities of directors in respect of climate change under both corporate law and securities law is the first comprehensive legal opinion in Canada. The opinion, as you will hear today, will go a long way towards clarifying the state of Canadian law. I'm also happy to announce that a certified legal translation of the opinion into French, undertaken by Miller Thomson LLP in Montreal, will be available on our website next week. Following Carol's talk and a Q&A period, and please post your questions into the Q&A box, we'll do our best to answer what we can. Professor Cynthia Williams, who is the principal co-investigator of CCLI, will offer some comments. With that, let me introduce you to our distinguished host for today, Gigi Dawe. Gigi leads the Corporate Oversight and Governance Department at the Chartered Professional Accountants of Canada, and herself is a very distinguished speaker on the issue of climate governance. Over to you, Gigi.
Thank you, Janice, and welcome everybody. I hope everyone can hear me. I am on my cell phone because Internet decided not to cooperate with this presentation today. So first, Carol, I want to congratulate you on a very necessary and tremendously informative legal opinion. You acknowledge in your opinion that there are numerous demands on boards, and although you're unambiguous about a call to action for directors, your opinion piece does not add to the demands, but presents informative guidance that makes clear the expectations related to climate risk. From my reading of the opinion, you're not presenting new expectations, but clarifying those that are already in place. As you note, directors know climate change is real. It's impactful to their companies, and they know that their actions impact others. Your paper is clarifying that what they need to do is bring that to the board table to ensure risks are managed. Just because it's difficult doesn't diminish the fact that it needs to be addressed. But I want to note that climate risks are just one of the complex areas directors need to understand. Directors are faced with digitization, vast amount of data that must be addressed for quality and accuracy to use in decision making. And just to put the dramatic increase in data into perspective, global internet traffic has grown from 100 gigabytes of traffic per day in 1992 to 46,600 gigabytes per second in 2016, and 150,700 gigabytes per second is forecasted for 2022. So there's a lot going on, but also they're dealing with cybersecurity risks, geopolitical challenges that impact economic and financial decisions, and there's also the economic impact of COVID. On top of that, climate change is complex. It requires directors to consider specific data, scientific data, and macroeconomic and policy implications. And often those are intersecting and uncertain. And it also requires taking a long-term view beyond traditional strategy timeframes. Carol, your opinion paper acknowledges this, but at the same time recognizes that directors know that banks, investors, regulators, and the courts are demanding that they consider these complex climate risks and that they need to ensure they get those risks into the board package. As you point out in the paper, boards are being given an undisputable message that they need to step up to the plate. Now, many of us listening to this webinar invest in companies or play a role to support boards. And we need to think about how can we assist boards to oversee climate risks and consider opportunities for the organization. You'll see from Carol's presentation that there are clear structures in place for boards to guide them, but we can provide direction that supports boards to follow through on that. Now, without further ado, I'm going to let Carol review her paper, and then I'll open it up to questions. Thanks.
Well, thanks very much, Gigi. And that was a wonderful introduction. I was just happy posted on the website. That was very well done.
Thank you.
And thank you, Janice and Cynthia and the and CCLI. I will say that there are lots and lots and lots of people who are making enormous contributions in this field. CCLI stands out and has done a wonderful job of facilitating the transfer of knowledge from experts in the field to the boardroom. And so I'm happy to have played some small part in the work of CCLI. What I'd like to do is give you an overview of the opinion. I'm not going to follow I'm not going to follow the order of the paper, because if you read it or have read it, that won't be very new to you. But let me run through with you why, as Gigi says, there's nothing new here. There's nothing new. So I want to start with, so the question we were asked is directors required to consider climate change? And let me just explain why we have said the answer is yes. And I'm going to go back into the legal theory and then bring it back out to climate risk management. So this is not, I understand that many people on the phone or on the webinar understand this already, but I just want to level set to make sure that we're all in the same place in terms of the analysis. So the directors, as you know, under most statutes are charged with responsibility for managing or supervising the management of the business. In most organizations of any size that are functioning as one might expect, the board delegates the day-to-day management of the organization to management. Management manages, and the board oversees. And the way in which the board oversees is by, first of all, approving the planning tools like strategy, which involves the review of risk, business plans, CapEx plans, all of those sorts of things. So the planning tools are approved by the board. Board essentially says to management, go ahead and manage to these objectives in this way and just keep us up to date. So all of the reporting back from management over the course of the year is reporting back to the board on the implementation of the plan. So the board, that puts us in the space where we recognize that the board oversees what management is doing. One of the biggest issues that any organization faces just through the operation of the business is risk. Risk is everywhere, and so what the whole risk management framework involves, first instance, identifying the risks, determining what's material, determining how to manage the risks. And then from a board perspective, the board needs to be satisfied that all of that is being done appropriately and receive reports from management on how the risks are being identified and managed. That then leads us to the question of, well, what risks is it that should rise to the level that the board that are material, that the board should be involved in, that the board should be aware of, and is climate change risk one of them? The reason that we have said that we think climate change risk rises to the board level, or in other words, should be put on the boardroom table, is because it has been so broadly acknowledged as a fundamental risk to the environment, to the earth, to financial stability, to the economy, to businesses individually. The consensus is so broad and so compelling. The idea that a board would not say where are we on climate risk, it seems to be, at this point, it seems to be not feasible. We say nearly impossible for a board to just dismiss it. How can you just dismiss out of hand a risk that has been identified by scientists around the world, by political leaders, by central banks, by expert panels, by investors? Broad consensus that this is a real and imminent threat. And how can people then operating a business say, I think that probably doesn't affect us? So that's the essence of what we're saying, that climate risk has been so broadly acknowledged that the boards of directors need to onboard that broad consensus and examine how climate change is affecting their business. So what is it the boards are supposed to do? Again, this is not going to be new to many people. So boards are collective. So boards make decisions as a group. Directors make decisions as part of a board. But the responsibilities are directors' individual responsibilities. So they make it's a little bit odd, but they make group decisions, but they're individually accountable for the way in which they behave. Janice mentioned it at the outset, fiduciary duty, which I will come to shortly. Directors owe a fiduciary duty, but they also owe a duty of care. And the duty of care is very fertile ground for directors in understanding how they should be approaching climate risk. So let me just parse that out for a second. So the duty of care requires directors to exercise the care, diligence, and skill, part one, that a reasonably prudent person would exercise, part two, in comparable circumstances, part three. Care, diligence, and skill, to be brief about it, I think you can just read the ordinary meanings into those terms. What's important to this analysis is the care, diligence, and skill that a reasonably prudent person would exercise. So let me give you 2 points there. So first of all, the concept of a reasonably prudent person is intended to communicate that there is risk in running a business. So directors don't have to be perfect. They don't have to be, they don't have to commit every waking second to dealing with the affairs of the corporation. They have to do the job that a reasonably prudent person would do. Reasonably prudent person. They don't have to be perfect, and they don't even have to be right, but they have to be reasonably prudent. One of the things that a reasonably prudent person would do would be to apply all the skills, knowledge, expertise that they have to the job of being a director. A reasonably prudent person, in our view, would be aware of the broad consensus internationally, nationally, and within the business community that climate change is a real and imminent risk. So the idea that a director could say to a hypothetical court, well, I wasn't aware of climate risk. I wasn't really aware it was such a big deal. I wasn't aware that it was a real and imminent threat, seems to be for us, is a very unlikely argument for directors to make in 2020. So a reasonably prudent person, in our view, would be taking climate change risk into account as part of the risk register. We say several times in the paper that not every organization is under immediate threat as a result of climate change, but they have to conclude that. So the conclusion has to be reached that we understand that climate change is an issue that there's broad consensus that the issue needs to be addressed. But for our business, for these reasons, and based on this information, we don't think we don't think that there is a threat to our strategic plan or to our objectives at the moment, but we're watching. that would be a fine conclusion for a board to come to if they can do it on an informed basis. So that's briefly the duty of care, and I'm happy to elaborate on that or take further questions on it. I want to move, though, to the business judgment rule, which is comes right up against every discussion about the duty of care. So if a director is not required to be perfect and is entitled to make mistakes, not illegal to make a mistake, isn't it always the case that the courts will defer to the business judgment of directors? And that is not true. So we have very good case law in Canada that teaches us that if the business judgment of the directors is not within the realm of reasonable, that a court will not defer to the business judgment of the directors. And so that brings us back around again to the question of, is it reasonable for directors in 2020, with all of the broad global consensus about the real and imminent threat of climate change, is it reasonable for directors to take no action, make no inquiries about the risks that climate change poses to the corporation? That would be the question. The other place where business judgment does not protect directors is in the world of disclosure. And again, we have case law on the matter. So the determination, the securities regulators, the stock exchanges have done a wonderful job of bringing the issue of climate change risk forward to corporations and to their boards. There is no change in the law. There's no need to have a particular section that deals with climate change risk because the law already addresses the obligation to disclose, if you're a public company, to disclose in your annual disclosure materials or in your material change reports the impact that climate change may have on your organization if it's material. The disclosure rules are legal standards. And so getting disclosure wrong, it's not a defense to say, well, it was my judgment that it wasn't material, because material is a legal test. And so you need to be correct on assessing materiality. I do understand that that's not always an easy subject, but the courts have said it's a legal test, and we don't defer to the business judgment of directors or officers in terms of determining what's material and what's not, again, because it's a legal test. So that covers, I think, the disclosure aspect of things. Let me just spend a minute on fiduciary duty, because it's, I think everybody's impulse is to drive towards fiduciary duty as the first of the two duties of directors. So I think everybody is aware that fiduciary duty, the directors and officers' fiduciary duty in Canada is owed to the corporation, not to the shareholders, not to the creditors, not to other stakeholders. So crystal clear that the directors can't prefer the interests of any stakeholder to the interests of the corporation. That having been said, the courts have also been clear that when there are competing interests of stakeholders, so the classic example is the shareholders want one thing and the creditors want another thing, it's up to the directors to decide whose interests will prevail. And the same tests that always apply to directors, you know, is this an informed business judgment? Do you understand what the interests are of the various stakeholders? How did you make your decision? All of those things continue to apply, but it's up to the directors to determine whose interests will prevail. We have not yet had case law on whether stakeholders, not in the way I'm thinking of, whether stakeholders like creditors or communities or environmental groups can take the position that they are a stakeholder whose interests the directors need to take into account, but there's no reason that that case law could not develop. So that is a very open area. The other thing that is oddly open, and I always think it's funny that people don't, there is more focus on this, in the two Supreme Court of Canada decisions that people typically refer to in connection with directors' fiduciary duty, Peoples and BCE, the court said in both cases the court said, that the duty of care, it's possible that a duty of care is owed to stakeholders, not just to the corporation. So the standard of care, if someone were successful, for example, in suing directors or officers under some theory of tort, for example, the standard of care that directors would be held to is the statutory duty that we've just talked about. So they will have to exercised the care, diligence, and skill that a reasonably prudent person would have exercised in comparable circumstances. So that kind of, I don't have an answer for that. It's an observation that that's what the courts have said, and there's an obvious space for creative litigators to drive into if they think they can make out a case under some theory of tort, likely. The last thing that I will say is, from a governance perspective, all of the tools are largely already in place. So again, there is nothing new here. There is a lot of really good material around, a lot of it produced by or on behalf of CPA Canada, that deals with the risk framework. There is a lot of knowledge about board composition, about what is delegated to committees, what the board should deal with, how risk should be considered, how it should be documented, how interest should be taken into account. And so the tools are there. The tools just need to be applied to this particular risk. So in summary, let me note that there is a lot of work that has already been done on climate change risk and how boards should deal with it. There are great providers around, like ESG Global Governance, that deals with how boards and management should deal with investor expectations, for example. Investors themselves have come a long, long way in making it clear to corporations what they expect to see in terms of disclosure. There has been a lot of movement, improvement, learning, understanding in the last couple of years. And so for boards, none of this should be new. Many, many, many boards in Canada are already doing a spectacular job, and are leaders internationally for the way in which they deal with climate change risk, with sustainability, with ESG issues. So we have a lot of great leadership in Canada. There are lots of organizations where, although it may not yet be a board level issue, because it hasn't surfaced to that level, management is actually doing a great job with climate change risk. It's already been embraced in various aspects of the risk management framework within an organization. It may just not have been pulled together under the topic of climate change risk and put to the board in that way. So for many boards who are not yet engaged in a deep way in the organization's management of climate change risk, I'm quite sure that many of them will find that it is already being managed very well. It just hasn't been put to the board in quite that way. So again, there's nothing new here. I think the issue really is accepting climate change risk, the global consensus that it is real and imminent, and figuring out how to onboard that into your risk register, into your strategy, and into the board's general oversight of the management of the corporation. So I will pause there and hand it back to Gigi.
Thank you. That was a great, interesting presentation. Really is quite a fascinating piece that you've put out there, and I think will be very, very impactful. Now, just one general question.
Sure.
Following your presentation. Were there any surprises for you when you worked on developing the opinion?
Oh, interesting. I will say, Gigi, in areas in which I don't practice, people are talking about climate change risk. And so I was really delighted to find the body of case law that we've discussed in the opinion, where courts in Canada have simply taken judicial notice of climate change and the existential risks, as they say, that it poses, or the threats that it poses for business. So the fact, when we say that a court has taken judicial notice of something, it essentially means you don't have to bother proving it to us. We understand it already. So the sun comes up every day. We get that. We don't have to need a lesson in that. And the courts have said in more than one case, look, we got it. You don't need to prove that to us. And so if it is not yet clear to everybody that climate change risk is broad, there is such a broad consensus on the importance of that risk, the courts have recognized it.
Okay, great. Another question. The oversight of risks as I think anyone would acknowledge, often very complex. And climate change is also very complex. Creating metrics and targets is even harder for board members. And all of this ends up being interrelated into the oversight of strategy, or is interrelated with the oversight of strategy. You spoke about a reasonably prudent person, the expectations of a reasonably prudent person. Can you talk specifically about what specifically is it that boards are expected to do here in overseeing climate risk? What in a bit more depth, what is it that they are expected to do? And I guess the second part of that could be, where do the responsibilities fall to management, investors, and advisors?
Sure. So let's put climate change risk aside for a second and maybe go to something that is right in, not climate change risk is not, but COVID is right in front of us right now. So it is completely clear. I think you could call it a very broad consensus that COVID has been a game changer. It has had an enormous impact on many, many businesses. Some have done well, some have not done well, but the idea that boards are not talking about COVID, I think is relatively unlikely, because it's affecting everybody and everybody understands that it's a risk. So COVID is a very good example of something where management needs to manage through it. There are a lot of functions, there are a lot of things that boards need to do in terms of thinking about the impact on strategy, worrying about whether the company is properly resourced, worrying about the HR components and things. So there are a lot of things that are not in the moment, but need to be taken into account, and that's partly the function of the board. So the board needs to make sure that they have their eyes on the issue. They need to understand when to insert themselves and where not to, because frankly, everybody is managing the crisis right now. So it might not be the right time for an offsite retreat for the board, given the other things that management is doing. But climate change risk is very much the same thing. You first of all have to determine how much of a threat is this to the organization. So directors will not, I would say very few directors who are climate change specialists. And so if the board accepts the fact that climate change is a real and imminent risk, they need to put that to management and say, we need some reporting to us on how that real and imminent risk affects this business and our prospects. And that connects beautifully into the long-termism that investors have been very focused on for a very long time. So in some cases, climate change is causing floodings and fires, and there are things that people are dealing with on a real-time basis. But it's not just the corporation that's going through these problems. The customers, suppliers, employees, business partners generally are dealing with the issues. And so if it is not on your doorstep, it may well be on the doorstep of a business partner who is critical to you. So all of those things need some definition. And that's something that the board doesn't come up with itself. It asks management to provide that to it. As I said previously, lots of management teams have got that information. It just hasn't been collected and presented to the board in quite that way. It may be that there are experts required to, not necessarily the board's experts, but experts that that the organization hires, and also provide reports to the board on how climate change risk affects this corporation. So once that has been identified, so we know there's a risk, we have assessed how big a deal it is, how material is it, and then the next step is to hear from management on how we are going to address that risk. So this should sound very familiar to people. It is the same pattern for dealing with most risks. It may be one that the board hasn't addressed before in that way, but they certainly have the tools to do it.
Okay, thanks. Now we've got a question here, and I'm going to add a little bit to it. But the question is basically, and you sort of started into this, but how much can boards rely on advisors, management, or other groups in order to determine where they go with risk? At which point do they stop relying, and how far can they go on relying on that? And my question I would add to that is, you often hear reference to climate competent boards or specialist directors, or that type of thing. What are courts going to accept around that? And are they basically going to expect boards to be climate competent? How far can boards go in terms of relying on others versus ensuring that the board is itself competent enough?
Okay, so let me take the reliance question first. It's really important in all of these discussions to keep in mind that management and directors are not opposed to each other. They're part of the same team. They perform different functions on the same team. So directors are set in the statute, discussed in case law. Directors are entitled to delegate to management, and rely on management in good faith. Very helpfully, the courts have said in good faith means an absence of bad faith. So if there is no reason for the directors not to rely on management, they can and should. So this should be a working partnership where the board needs to be comfortable from an oversight perspective that things are being managed properly, and management needs to be transparent with the board so the board understands whether things are being managed properly. So if you're relying on advisors, you need to be confident. So outside consultants, you need to be confident that the advisors have got the skill set necessary, that you're not relying, if you're looking for advice on real property issues, you're not taking that advice from an intellectual property lawyer. So make sure who you're getting, which seems obvious, but make sure that you're getting the advice from the appropriate people. But directors need to apply their business judgment to the information that's being provided to them. But I don't think the first worry for most directors is, geez, I wonder if I can rely on management. They need to understand whether management has got the skill set to be able to do it, not in a challenging kind of way, but climate change is very much like cybersecurity. So I think we've all talked many times about the fact that one of the biggest challenges with cybersecurity is that boards are not skilled in the issue, or cyber generally, not skilled in the issue, and there aren't that many managers, senior executives who are skilled in the issue either. And so everybody has to work through it together. There's nothing about the legal framework that requires people to do things that they're not capable of doing. And the second part of your question, Gigi, I'm sorry, I lost track of.
The second part of the question is, would the courts be expecting boards basically to be climate competent?
No. So I would say as a general statement, the courts will expect shareholders to determine who should be on their board. So what a court will look to, for example, with the duty of care, is to make sure that each individual director has taken the care, diligence, and skill that a reasonably prudent person would take in comparable circumstances. That's what's required. And so a reasonably prudent person, again, would apply the skills, expertise, experience that they have, not that some fictional person has, that they have, diligently to the job before them. So I don't, whether or not it is a good idea to get climate change experts onto boards, we could discuss. So first of all, I'm not sure what a climate change expert is. If we go back to another issue that many people remember, the Y2K issue, as in the lead up to the change in the millennium, many boards were getting IT specialists on their boards to make sure that they were dealing appropriately with Y2K. In some cases that worked out beautifully and they were excellent directors, but in many cases what you ended up with was somebody who had a single skill, was not otherwise a great director, was a subject matter expert to whom everybody else deferred, and so you did not get the benefit of the reflections and judgment of the other directors, and that it was otherwise an empty chair at board meetings. So at least in my experience in dealing with succession planning with boards, it's not really so much even now that people are looking for cybersecurity experts. They're looking for people who have dealt with technology changes, transition issues. You're not necessarily looking for the subject matter expert. You're looking for somebody who has managed the issue.
And that actually is, it's interesting because it leads to another question I'm seeing here. Do boards actually need to be climate competent or risk competent?
Yeah, so I agree. I think you're leading me a bit, Gigi, and I'm fine with that. I think it's risk competence. Yeah. And that is, you know, there are so many great tools available. Again, many of them developed by CPA Canada. There's just no shortage of resources for directors in being able to understand better how they should deal with risk generally. So I'm reminded, Gigi, in particular, that really excellent piece that John Caldwell did on
just the second edition was just put out. So
just a spectacular piece, very accessible, readily available, great resources.
Yeah. I'm only going to ask questions that relate to resources from CPA Canada from here on in. And actually, I'm going to go way off that. What questions should pension funds and asset managers be asking of their investee companies regarding these matters?
So you know what, Gigi, I'd like to take that, it's a good question, but I'd like to take that from a slightly different perspective, just to bring the investor perspective into the conversation. I think one of the really great developments in the last short while has been the investment community getting behind the TCFD framework. So just for those who are not familiar with all of these frameworks, there has been a great deal of effort put in by a lot of really dedicated people to develop frameworks within which organizations can understand climate change risk or sustainability or environmental, however you want to frame it. And the challenge, I think, for organizations has been, wow, which one of these am I supposed to use? Because they are very time intensive. And once you've adopted one framework, the switching costs are very, very high. So adopting a framework is a very big deal. So the TCFD framework came out of a task force that was established by the Financial Stability Board. At the time it was headed by Governor Carney, what's our central bank governor. And it provides a very accessible framework within which to think about climate change. And I won't say any more about it than that because it would take up another 4 hours. But that combined with the SASB framework, so SASB has developed, I think they looked at, I may get the numbers a bit wrong, 79 different industry groups, and they had identified issues for 74 of them. So when you're thinking about climate change, think of this, think of this, think of this. And so the SASB framework combined with the TCFD framework seems to be now out ahead in terms of what's what's the most highly thought of. It is an enormous help that the institutional investor community is getting behind a specific trend, make it much easier for organizations to make their decisions. You'll end up with disclosure that is comparable. So we don't have the benefit of generally accepted accounting principles in the climate change world, but if there is an agreement on a common framework, it will make it much easier for people who are trying to understand how climate risk is being identified and managed in individual corporations when they compare the disclosure of a corporation to corporations in the same industry.
Yeah, and I would add that I think SASB, I agree with you. SASB's created some great standards, some great guidance around standards, and particularly in TCFD, if you look at section B, I think it's section B, that has some very concrete, direct steps that can be taken that are, some really good guidance there too.
Right.
So.
Right, and so that's a very big help for boards, I think, that the institutional community is taking those steps. And I think those frameworks themselves provide a good guide for investors in terms of the kinds of questions to ask boards or to ask management teams. So it provides a common frame of reference for the discussion.
Great. Okay. Now you discussed the obligation of directors regarding the disclosure of climate change, and the business judgment rule it doesn't sort of work, I guess, the same way for that. If you, how do those, if you could just talk a bit more about how those obligations informed your thinking on this sort of legal opinion, and did it change your thinking? What was the impact of that?
The impact of
the opinion of overall around the disclosure issues.
Oh, I see. I see. Yes. So first of all, disclosure. Important to note. I think the disclosure is the second step. It's not disclosure for the sake of disclosure.
Yeah.
What I think people want to know is, what are you doing? And so first of all, you have to be doing something. And so the disclosure obligation often raises the bar in terms of performance, because now you're going to have to explain it. You look at everybody else's disclosure and say, well, we're not doing that, so maybe we need to take another look at that. So that's I think the disclosure obligations, as I say, raise the bar. Obviously important to provide investors with the information they need to make investment decisions. We outline in the paper a number of different ways in which the investment community influences the way in which their investee companies deal with climate change risks. They make the investment decision. This company, I'm comfortable with this company, I'm not comfortable with this company. In some cases, they will initiate or support proposals that are related to climate change. In some cases, they will withhold votes from directors, either because of the individual director or because of the position they hold in the organization, that the company is not addressing climate change appropriately. And so the investment, one of the things I think is just great about the Canadian governance environment is it has largely been formed by the investors. We have far less governance regulation in Canada than they do in the United States, largely because we don't need it. The investor community has been very effective on issues that I think everybody takes as kind of obvious now, say on pay, majority voting. All of those things are obviously an important part of transparency and accountability. And I think similarly, the investment community focusing on climate, they made a huge difference in diversity is another issue. So diversity has, I think, hit organizations differently since the institutional investors have said, it's important to us. So with the institutional investor community has had such an important influence on the move to long-termism. Their continued focus on the need for reporting that will guide their decisions will continue to influence the performance of particularly public companies in Canada on the climate change risk issue.
Okay, thank you. I've got another fairly long question here. So the management of climate change risks can be a competitive advantage for companies. Your paper appears to focus on the risks per se and less on board responsibility to create opportunities. Can you speak to the duty of care in this case? What are the liability consequences for directors from failing to consider the opportunities in their strategic oversight?
So failing to take advantage of an opportunity, I'm just trying to think of whether I've ever seen it. There's certainly lots of cases where directors have been not necessarily liable, but criticized for rushing into new ventures where it turned out to be very, very bad decisions. I'm not sure that I've seen a situation in which directors have been criticized, certainly not liable, for failing to take advantage of an opportunity. So we were very conscious of focusing on the risk aspect of things in the opinion, because I think, as you're intimating, Gigi, the opportunity side of things is a whole different world. So for every risk that you look at, there is a threat and there is an opportunity. How boards hear from management on whether they're recognizing those opportunities or not is a very industry specific kind of issue. So I don't think it's a very important issue. It's not one that I would worry about as attracting liability, though.
Okay, and further to that, there was another question. Isn't it unlikely in Canada that any directors would be sued on a breach of fiduciary duty grounds given the business judgment rule? Can we really expect that directors in Canada can be sued for failing to take climate change seriously?
Well, so I never like to focus board performance on do it or you'll get sued. For the most part, directors are interested in whether they're doing their jobs properly. So what is it that I need to do in order to be doing my job? I think that's what good directors are interested in, but I will address the liability issue. But people can sue you for anything. And if you're worried about whether a court will ultimately say that the director did such a bad job, they will be personally liable. So we're driving right into your bank account to put the money back in the corporation. I agree with the sentiments probably being expressed by the person who phrased the question. That is very unlikely. However, there certainly have been lawsuits around climate change. There have been lawsuits, court decisions around risk management, where the risk management was criticized by the courts. So that is not a stretch at all. The ultimate, a court says you did it wrong and so pay up. That's the reality is that you get sued, and then there's settlement discussions. It's very expensive. It's very emotionally hard on the directors. The reason we don't have enough case law is because people settle.
Okay. So a follow-up to that then would be, in Canada, we have a huge number of small to mid-sized organizations. It's a vast majority of companies in Canada. That may impact the sophistication of the boards. In addition to, in many cases, those smaller companies are really just working to keep their heads above water and to just keep the company going. Would they be held to a different standard? Could they be held to a different standard?
No, so there's always an impulse to say that there are different standards for different people or for different companies. There's the one standard. If you're talking about the directors, there is the one standards in the statute. So there is the one statute. There's the one standard. So, potentially you could shelter under the incomparable circumstances part of the case, part of the test. But a very small organization with limited resources has a harder time reacting to many things. I think the question would be, for this issue, did you talk about it at all? So if you are if you're an organization that has a lot of real estate, whether or not you're big, let's just imagine you've got a lot of real estate in a number of just jurisdictions. Climate change is a pretty real threat because of catastrophic events like floods and fires and that kind of thing. And I think the people who are, this is not some, vague concept that, maybe the directors will talk about over drinks. It's the thing that the operators are actually worried about. If climate change is a real risk, a good operator will understand that, we are there have been a lot of fires here, or, those fires in Australia have completely dried up a part of our supply chain. What are we going to do about that? So it's not, I think we tend to think of these things because in order to write an appeal, we're dealing with everything at a very, very high level and not pulling it down to the practicalities because we don't have a fact pattern in front of us.
Yeah.
But the organizations do. And so I think the operators are probably very well attuned to these issues. And that's what the board should be asking about.
Okay. And there's just a follow-up question to that, or follow-up question I would have to that. Many of the small organizations do work internationally, or their supply chain is big. Can you talk about what's happening in other jurisdictions around this? And comparatively, are expectations different? Could this put Canada at a competitive disadvantage, or is Canada at a competitive disadvantage due to our legal structure around this?
I don't think it's so. I think the legal structure, I think the basic concepts of fiduciary and duty of care, fiduciary duty and duty of care kind of apply generally to the relationship between officers and directors in the corporation. So I don't think you're gonna find jurisdictions where directors and officers can do whatever they want. They're not accountable for their actions. That just doesn't align with the whole concept of people operating a business on behalf of other people. The awareness of climate change risk, or the onboarding of sustainability issues, disclosure, and so forth. My own very simple comparison would be that in Europe they've been dealing with this much longer and much more effectively. It's newer. A lot of Canadian companies have maybe been thinking about it longer than some American companies, but it's certainly an enormous issue in the United States now as well. If you're the competitive advantage question is a little bit difficult to answer, but I would point to an observation we make in the paper, in the opinion, that your climate change disclosure can affect the investment decisions that investors make. And so if you just put it very, very simply, if an investor is looking for a particular, they're looking for good, solid recognition and management of climate change, and they have 50 investments in front of them, and they put into one pile the companies that don't seem to get it or address the issue, that affects your cost of capital. So if investors are are less likely to invest in you because you don't get it or you don't disclose that you get it, that's not good from a capital markets perspective.
Great. Thank you. I think there are a number of questions, and we have hit the end of our time. Cynthia's going to do a wrap up at this stage. So thank you, everybody, for the questions that were sent in. Thank you, Carol, for a great presentation and for responding to questions coming from all over. So this is great. And I guess, Cynthia, over to you.
Okay, well, thank you very much. I hate to interrupt this discussion. It's so interesting. But I want first to thank both Gigi and Carol for your time, not only today, but for that time and energy that you've spent addressing the serious issues that boards face. And in my few minutes here, I just would like to make 3 points. First of all, we would like to acknowledge, Carol, the tremendous amount of time and effort research and thought that you and your team put into this opinion. We appreciate it very much. We recognize that many law firms across Canada have issued memos and do recognize that climate change is real and that boards need to address climate change. But what Carol's opinion does so well and so uniquely is to pull together the international and national sources, the scientific bodies, the courts, and the regulators that recognize climate change risk and opportunities, and bring those together to towards the fiduciary duties, the duty of care, and the duties of disclosure. So we hope that many lawyers across Canada will look to this opinion and will use this opinion in their work with boards. So thank you. Second, I would like to say, we would like to say, to acknowledge the potential for this opinion to make a difference, not only in other countries, but in policy circles. An opinion in Australia by a senior member of the bar there, Noel Hutley QC, was a precursor to this opinion. He issued his opinion in 2016 and then updated in 2019. And the Hutley letter was influential with securities and accounting regulators in Australia and also influenced our thinking in Canada. An opinion is currently being drafted in Singapore, and the council there have already asked us questions about the Hansell opinion. We, Global CCLI, will be starting work in the United States this fall, and we certainly will be using the Hansell opinion as a model there. But well beyond our efforts, I was reminded very recently by a World Bank official that Canada punches above its weight in global policy circles. We are all aware, of course, of Mark Carney's role when he left Canada to take up the post of Governor of the Bank of England, and his instrumental role in initiating the task force on climate-related financial disclosures. But also with respect to IOSCO, the International Organization of Securities Commissions. IOSCO was started by the Quebec Securities Commission in the early 80s. And it was first established as a legal entity in Montreal in 1983. That has two representatives on the IOSCO board, and those are the Securities Commissions of Quebec and Ontario. So hopefully this opinion can be used by our colleagues and our friends within the Canadian Securities Commissions, the Canadian Securities Administrators, and IOSCO to further develop policy supporting the important corporate governance role of boards with respect to climate change and their disclosure obligations, further supporting TCFD. And finally, we really want to acknowledge the excellent work being done by many other people and organizations to develop the analytic tools that boards need to do the work that the Hansell opinion makes clear boards must do. CPA Canada has been mentioned for their excellent guidance oversight, and it has recently developed tools for members of the C-suite to use to analyze financial risks. The Global Risk Institute has developed specific tools for financial institutions to use as part of their fundamental financial analysis of climate change risks. The Institute of Corporate Directors is including climate change tools in its board training. The World Economic Forum and its Chapter Zero initiative, led by an expat Canadian, has developed board tools as part of its Directors Climate Forum. And these are just a few of the initiatives creating the analytic capacity for boards. And any board member or executive who wants to meet these challenges should know that there are many tools out there and many of us stand willing to help. We would be very happy at CCLI to connect boards and executives with these excellent resources. So on that, I would like to say thank you, everyone. This task needs all of us, including every single person on this webinar. And we want to thank everyone who's taken the time to join the webinar, but particularly Carol Hansell and her team for their excellent work, and Gigi Dawe for her leadership in this regard. Now let's get to work.